All right, welcome back for our final presentation, Board Member DLSC Training Part 2. So I will turn this over to our DLSC presenters. The first presenter you will hear from today is Leslie McKinney, who is a prosecuting attorney in the Division of Legal Services and Compliance. She works cases involving allegations of professional misconduct against licensees of various health professions. Leslie will provide training on investigation, open for legal action, and hearing from assignment to agenda. You will also hear from Adam Wagner, who is a senior regulatory specialist and DLSC monitor. He also serves as the DLSC professional assistant procedure coordinator. Thank you.
All right, as Renee introduced me, I am Leslie McKinney, and we're going to do a little bit of a deeper dive right now in disciplinary cases from the point you're assigned as the case advisor to the time that it hits the agenda and the board deliberates on it. Mary and others have gone through a little bit of it, but we're going to get into some more detail. Once a case is open through screening panel, the case is assigned to a case advisor and a team within DLSC. DLSC then investigates the allegations. The DLSC and the case advisor then collaborate on an appropriate potential resolution, and then there's various steps that lead to the final disposition of the case. Case advisor can be assigned in several ways. One way is by the screening panel during the screening process, where this case advisor will be named by the panel to the screening attorney, and that will be passed on to the DLSC team. Areas of expertise. A screening panel member's area of expertise, or from the board in general, it doesn't just have to be a member of the screening panel assigned, may make that board member more appropriate to advise on the case. For example, a nurse prescriber on a case that comes from the Controlled Substances Board, or a specific medical specialty in a standard of care case. Public members aren't necessarily excluded from serving as a case advisor when there's no specialized experience required. These would be administrative type cases, such as a case is open for respondent's failure to respond, failure to report a conviction in a timely manner, a question of continuing education credit completions, or other administrative issues like that. DLSC staff can also assign case advisors. Usually the DLSC attorney can request the assignment or reassignment of a case advisor, and this most usually happens when a specific case advisor's expertise or experience would be more appropriate for that particular case. This can happen at the beginning of the case or as the investigation progresses. Information may be discovered while the case is being worked that leads to the need of an area of a more specific individual's expertise. As you've heard before, a case advisor will be advised via email that they have been assigned a new case. And we ask that you review the case if you're assigned as case advisor as soon as practicable, because we want to determine if there's any conflict of interest or bias that would require reassignment early on in the case. Such conflicts can include personal relationships with anyone involved, the complainant, the credential holder, a witness, and this can be a good or bad personal relationship. Any type of financial interest, for example, we wouldn't want a pharmacist as a case advisor in a case against the pharmacy they work for. If there's any question or concern that there may be a conflict once you're assigned as case advisor, please feel free to discuss the matter with the attorney assigned to the file. Now, merely knowing or knowing of a person involved in the case is not necessarily a conflict. A conflict only arises when there could be a bias or a perceived bias. For example, there would be a conflict if the case advisor was aware of the facts and circumstances of a case through sources outside of this particular disciplinary process. If the case advisor had a close relationship with the individual, family member, good friend, family member of a good friend, but we'll consider the nature of the relationship that we're examining, plus how remote in time that relationship may have been. An example of something that wouldn't necessarily be a conflict is if, as case advisor, you said 10 years ago, we worked at the same place, but we never really worked together. I just knew of this person. That would be evaluated, and chances are it would be difficult to find a bias or perceived bias, so there wouldn't necessarily be a conflict. Now, the case advisor has a duty to maintain confidentiality, cannot discuss pending cases with other board members, colleagues, or friends. But if an issue arises that, as case advisor, the question may be outside your specialty or area of expertise, you can consult with a colleague that may have more information or knowledge to help you informing your opinion. There are exceptions. You cannot consult with another board member in that instance. And identifying information specific to the case, the complainant, the respondent, the facility where it happened, the business involved, that cannot be disclosed. Now, you need to remember that DLSC also handles unlicensed and direct licensing cases which don't have case advisors assigned. When the attorneys or the investigators need consultation on these types of cases, we sometimes reach out to board members who have served as case advisors on a related issue or may have that type of knowledge. That doesn't make you a case advisor on that case. It's merely us seeking your knowledge and expertise. And I cannot reiterate this enough. Do not discuss your cases with fellow board members. This can result in not only open meeting violations, but it can also conflict members out of the board's deliberation, possibly resulting in a loss of quorum when that particular case is deliberated. And I know it was mentioned earlier that no ex parte communications are permitted, must not communicate with individuals involved in a pending case, and this has happened, if a party, witness, or other individual attempts to contact you about a case, please advise that person you cannot discuss the case and let the attorney on that case know about the attempted contact immediately. We touched on how case advisors are assigned to a team. Let's talk about how the DLSC team is assigned. And as Gretchen mentioned, the DLSC team consists of an attorney, an investigator, and a paralegal. One method that team is assigned is the team within the team. DLSC attorneys and investigators are generally divided between those who handle business boards and those who handle medical and health boards. A good example is within the health team, we're even narrowing that team down more. Attorneys are often divided into more particular boards. A lot of separation, not required, but happens. There will be attorneys that specialize with the medical cases and attorneys that specialize in the nursing and other health team cases. It's not a wall that they can't climb, but it's just general assignment. There's also a general rotation of attorneys within DLSC. Intake maintains a spreadsheet and the rotation continues with investigators, attorneys, and paralegals. And this helps to even out the workload. The fact of a companion case can affect assignment. There are times when complaints are received that involve the same respondent, similar issue. These cases can be made companions and can be worked together by the same team. This can also be done with the same respondent and perhaps a different issue when discipline in one of the cases would encompass the other case. A good way to think of that is that you can really only revoke a credential one time. So cases can be companioned on different issues when the more severe case would cover the discipline in the less severe case. There's also assignment based on experience with similar issues. There are times when we will have an influx of cases that involve a specific specialized issue where one team will usually be assigned all of them. Over the past couple years, we saw this with ivermectin cases during the pandemic, stem cell cases, things where specialized knowledge is required. We already have one team that has gained that knowledge, so they'll keep working the case. It carries over, the knowledge carries over to all the cases, and having the same team cover it promotes efficiency. During the investigative phase, a case advisor may be called on to assist the DLSC team as a subject matter expert. And as it's been discussed and repeated, but it bears stating again, some of the questions will be, what are the minimal professional standards of that profession as they relate to the allegations? This is to be distinguished from best practices. And remembering that while there may be differences of opinion on what could have been done or how something was performed, discipline is only appropriate for credential holders who have fallen below the standard of minimal competency. We're also going to look at what evidence should be available in order to establish whether those standards have been met. And we may consult with the case advisor on this because as a credential holder, the case advisor may know of a required act that should have been performed, a piece of evidence that the DLSC team as lay people may not know should exist. For example, with a certain act, is there a required document? The case advisor would be able to tell us that. And there's many cases where the case advisor's technical expertise is invaluable in guiding the investigation. Once the DLSC team is assigned, the attorney will review the case for investigative needs. One of the first steps in that is comparing the available facts to the applicable law and balancing that against the burden of proof. If more facts are needed to determine the applicable law, or more evidence is needed to meet the burden of proof, the attorney will send a request to the investigator to obtain those specific things. That rinse and repeat, the comparison, obtain more, comparison, obtain more is the generalized investigative process. Sometimes it's incredibly straightforward, sometimes it's not. Some good examples of a straightforward investigation will be uncomplicated standard of care documentation issues. For example, a complaint alleges a failure of a doctor to perform a required act in a required manner. A review of the medical records may be all that's needed. Or a real estate agent could be alleged to have not used an approved form. Examine the form used, and that can establish the existence or non-existence of a violation. Many times, a respondent will admit to allegations of blatant misconduct. A nurse can admit to injecting heroin in the bathroom during her shift. A funeral director can admit that one of his or her non-licensed employees transported a body. They admit to the misconduct, straightforward, move on. There's also administrative and purely statutory violations that can be straightforward violations and investigations. A respondent could be alleged to have not reported a conviction within 48 hours. Investigation can be as simple as comparing the date of the conviction to the date that the respondent reported it. Could be as simple as non-compliance with continuing education requirements, where the investigation 100% consists of counting the hours in the course completion documentation to see if it meets the statutory requirements. There's some not so straightforward investigations. And one of those areas may be there's a lack of an applicable law. There may be times when a respondent's conduct may instinctively feel wrong. And that can be referred to, and we sometimes call it the lawful but awful case. The board's authority and due process requires that discipline can only be imposed for a violation of a specific statutory or code provision. Regardless of how strong the desire may be, conduct that's not a violation of statutory or code provision can't be disciplined. A good example of that is a person who's not a patient, client, customer of the respondent, was in a romantic relationship with the credential holder. The relationship didn't end well, and now this person is making complaint alleging terrible conduct by the credential holder, cheating, things like that, in the context of the relationship. It's terrible. We may not like it, but we can't discipline under the board's authority at that point. We may have a credential holder who is spewing vile, neo-Nazi, racist propaganda on their personal social media pages. There's no allegation of any practice-related misconduct. While this may be conduct that the board wishes to halt, and most of us definitely would, the board is without authority to do so. In fact, the United States Supreme Court has gone as far to say that constitutional rights are not forfeited merely by virtue of being a licensee. This can include issues such as jurisdiction, things like that. And in most cases, once a credential is issued, you can't really discipline for conduct that happened prior to the issuance of that credential. Now, misrepresentation when applying for the license may be an issue. For example, discipline may be imposed for pre-credentialing conduct that was required to be reported in the application process, but was not. And that's a little bit different from conduct that happened before the credential that's now being discovered afterwards. Another type of investigation that might not be as straightforward as others is when the case involves meeting the burden of proof. Our burden of proof in disciplinary cases is a preponderance of the evidence. That means that we need to show that it's more likely than not that a violation has occurred. We must assume when we're investigating and preparing a case that every case will go to hearing. Once discipline is proposed, we must be confident that we can meet that burden of proof, because at hearing, unless that burden is met, the respondent prevails. So in every case, we must be able to prove that the alleged conduct more likely than not occurred, the named respondent committed that alleged conduct, and that conduct in itself is a violation of our statute or code. We'll frequently find burden of proof issues in he said, she said cases that involve contradicting evidence of equal weight and credibility. One party alleges, the other denies, and there's no independent witness or evidence. We can find it when there's an inability to substantiate a violation with the needed evidence. This can happen when a credential holder is alleged to be impaired with drugs or alcohol while at work. They deny that they were. Witness statements describe observations that may have many other non-impairment explanations. No drug screen was obtained at the time of the incident, and the respondent has a medical provider who confirmed a diagnosis of an alternative basis for the physical actions that the witnesses observed. It's going to be very hard to meet the burden of proof. We may feel like the violation occurred, but if we cannot show that it's more likely than not that it did, we cannot prevail. We determine an investigation is complete when there's been sufficient evidence gathered to meet the burden of proof that a violation occurred. And this most often results in a disciplinary recommendation. And it's important to note that investigations may sometimes reveal violations that weren't alleged in the original complaint. These violations are subject to discipline as well. The investigation can be complete when sufficient evidence is gathered to show that a violation just has not occurred. And this most often ends in a finding of no violation. It can end when there's no remaining outstanding evidence that we could obtain that would be able to prove a violation occurred. That usually results in a closure for insufficient evidence. And there's other investigations can end when there's other actions that have taken place that address the alleged conduct. For example, a respondent has surrendered their license, the board has already taken action through the credentialing process or some other mechanisms, a provision of a licensure compact applies. Depending on the action that is used in this section, a variety of closure recommendations could apply. Once DLSC has completed their investigation, we'll provide the case advisor with applicable case materials. We'll also provide the case advisor with an analysis of the case and a written case summary, which will include possible disciplinary recommendations. The attorney's analysis and recommendation is based on the application of the evidence-based facts to law. This can include relative strengths and weaknesses of the case, mitigating and aggravating facts, and can also provide alternatives for discipline or informal closure. We'll look to board precedent in similar prior cases. And adherence to board precedent is valuable for consistency and notice to other credential holders. And while valuable, it's not absolute. There are distinguishing factors that may warrant a departure from precedent. There also may be cases of first impression where the board has not faced the issue before. Repeated violations, including allegations and discipline, may result in escalated discipline, which involves a credential holder's prior disciplinary history. And we also always looked at the severity of the conduct. Depending on the complexity of the case, this may be the first time that the case advisor has communicated with DLSC team in this case. Don't be alarmed if the investigation has been going on, but we're reaching out to you when we're reaching out to you because we need you at that point. The most important factor in ensuring an efficient, effective, and appropriate case resolution is clear communication between the case advisor and the DLSC team. When the DLSC team reaches out to you, your response may include agreement with the recommendation that the DLSC attorney made for closure, an alternate recommendation, questions regarding the evaluation or the recommendation, or requests for more information or more possible evidence. More information, more evidence that will be gathered with further investigation. We ask that a response is provided to one of these disciplinary recommendation requests within 10 days of receiving the case materials so that we can move this case forward. As discussed before, the state has 3 objectives in disciplining credential holders. We want to protect the public, deter similar conduct in both the respondent and general deterrence across the credential, and rehabilitate the credential holder. We are not here to punish, we are here to protect, deter, and rehabilitate. Cases can be resolved informally without any written order, with a non-disciplinary written order, and with a formal written disciplinary order. The 3 most common types of informal closure, where there's no written order involved, it's a finding of no violation. We have not been able to bring facts forward to show that a violation occurred. Insufficient evidence. We don't have the evidence to meet the burden of proof to show that a violation occurred. Or prosecutorial discretion. A minor technical violation had a minimal threat of harm to the public, and it's just determined that formal discipline isn't warranted. An example of this would be, instead of a credential holder updating their address with DSPS within 30 days, they updated it on day 37 without prompting. Yes, they committed a violation, but there isn't a lot of point in disciplining that. Or compliance with statutes and rules has been gained. Let's say a case is open for failure to respond. Respondent eventually responds and provides an excellent explanation for the delay. Yes, there was a violation, but we've shown that compliance has been gained and no further action is warranted. There are also 5 basic types of formal case closures. One is the administrative warning, an AW. There's a remedial education order, an REO. There's a reprimand, suspension, and revocation. Administrative warnings are not considered discipline. They're issued in instances where it's a minor violation and the credential holder has not previously committed a similar violation. As mentioned before, the fact that a warning was issued is a public record, but the content of the warning remains confidential. Administrative warnings can be used in later disciplinary proceedings as evidence that the respondent knew that this type of conduct was a violation. Next is the remedial education order, or REO. They are not considered discipline. REOs are issued when the board believes that the conduct can be sufficiently addressed with additional education, and it doesn't include a specific finding of a violation. The case advisor and the DLSC attorney discuss the number of hours and topics to be addressed in the education, and those are all specified in the order. And these are public orders. REOs are public orders. Next up is the reprimand. A reprimand is the lowest form of formal discipline. It lists facts, findings of fact, and specific violations in the order. They are public orders. Now, once a resolution resulting in formal discipline, such as a reprimand or above, is reached, the respondent is also responsible to reimburse the cost of the case and the proceedings, from intake through investigation through final disposition. Step up in severity from a reprimand is a suspension. Suspension withdraws the credentials holder privilege to practice under their credential. It can be time certain or indefinite pending satisfaction of other board requirements. For example, the board can say, we want this respondent to complete X hours of this type of education, and they are suspended until they have completed that education. Suspensions can also be imposed and stays given as well. A credential holder may need to petition the board to request the lifting of the suspension. A step up and our most severe form of discipline is the revocation. It completely terminates the credential holder's privilege to practice and their right to renew their credential. It's used for the most serious of violations or for repeated discipline misconduct. It's allowed in some cases, in statute, in fact, that the credential holder may be permitted to reapply for his or her credential in the future. And this is usually not less than 1 year after the revocation. Within those categories of orders, there are some specific types of orders. One is a monitoring order, and these are used in instances of drug use, mental or physical impairment, drug diversion. They're usually ordered on terms of 2 to 5 years. They may include a suspension, and they provide a structure for drug testing and treatment with oversight on the department. And Adam will be discussing those, I believe, a little bit more. There are voluntary surrenders where the credential holder may choose to surrender their license to avoid revocation, save the time and expense of defending against a disciplinary case, or they can also be used in instances where the licensee who's being investigated has retired. These may or may not include a specific finding of violation. Some boards have the authority to cite violations and or order the payment of a monetary penalty in lieu of or in conjunction with a disciplinary order. And Mary briefly discussed summary suspensions that are available when the facts establish that the credential holder is engaged in such conduct that emergency suspension is required. And since summary suspensions circumvent due process, there are rules in place that require a hearing within a specific period of time. We also have interim orders, which are stipulated orders that the respondent agrees from refraining from practice or some other conduct during the pendency of the disciplinary case. Interim orders remain in effect until final board disposition of the disciplinary case, and they can often be used in lieu of a summary suspension. Once the DLSC team has received the closure recommendation agreement from the case advisor, if it's an informal closure, such as a no violation, insufficient evidence, etc., the case summary is finalized and the case is submitted to the board's next available agenda. If an AW is recommended, an administrative warning, DLSC drafts the warning and it's submitted to the board's next available agenda. If an REO, remedial education order, or discipline is recommended, DLSC drafts a proposed order and presents it to the credential holder to stipulate. A credential holder will stipulate when they choose not to contest the findings of the investigation or the proposed recommended discipline. The credential holder signs the stipulation form and accepts the terms. No stipulated order goes into effect until it's approved by the board. And the process leading to a signed stipulation may involve negotiation of the terms and language of the order. And either before or during the negotiation process, the DLSC attorney will consult with the case advisor on specific order terms, a range of appropriate discipline, or sometimes just a bottom line of acceptable discipline where the attorney can go in negotiation if needed. But if a credential holder refuses to stipulate, the case proceeds to a formal hearing. To start the formal hearing, DLSC files a formal complaint to take the case to litigation in front of an administrative law judge. The DLSC is the attorney, is the prosecutor, and the credential holder may do this themselves or have retained an attorney. They present their defense. It's conducted very similar to a regular hearing in court with testimony, witnesses, and exhibits. And following the hearing, the ALJ prepares a decision. The parties are given time to submit objections to that proposed decision before it's presented to the board. The board then issues a final decision in order. The board can accept the recommendations that the ALJ has written or can change them, in which case board legal counsel will draft an amended decision, which is called a variance. When the board deliberates a case closure, if it's a proposed stipulation that's been signed, an administrative warning, or an informal case closure, you as the case advisor may participate in those deliberations and may vote on the matter. In fact, as case advisor, you made the proposed closure recommendation. So you should be prepared to speak in support of the agreed upon resolution, discipline, or closure. If the proposed decision is coming to you following a formal hearing, as case advisor, you may not participate in the discussions or vote on the matter. And the reason is because you may have access to information that was presented in hearing or not presented in hearing, but was part of the evidence in the case, could have been not admitted as an exhibit. The ALJ could have ruled that it couldn't be included. And you having that knowledge would make it improper and unjust to the credential holder for the case advisor to report information that was not proven at hearing. Comes time, whether it's stipulation or proposed order from the ALJ, that the board is going to deliberate. Deliberations occur in closed session where the board reviews the proposed resolution to the disciplinary case. The board asks questions regarding issues in the case during its deliberations. We can call in the DLSC attorney on the case to address or clarify those issues. If the proposed resolution is approved, DLSC will close out the disciplinary case by letting the credential holder and the complaining party know and providing a signed copy of the order to the credential holder as applicable. If the board rejects the proposed resolution, the case is returned to DLSC with further guidance and the appropriate level of investigation, and the process resumes. Investigation, evidence meet the burden of proof, fulfill the board's request until it's brought back up to the board again. And that is how a case goes from assignment to final disposition. And I believe it is time now to hand it off to Adam.
Very good questions.
We'll do it at the end.
Okay. All right, so I'm Adam Wagner. I'm the Senior Regulatory Specialist and I'm the Professional Assistance Procedure Coordinator. So basically, after everything is said and done, these cases, if they're put on monitoring, come to the monitoring unit. Monitoring unit consists of 5 people, 4 monitors and our 1 supervisor. So basically, as I said, after everything is said and done, they come to us. The case is closed, they've been put on monitoring, and nothing else can be deliberated regarding the case. This is the final decision. And they obviously already know that because they've signed off on it. All right, so the biggest importance of monitoring, and as I'm assuming you guys have all heard throughout this whole presentation, is to protect the public. But another big promotion of that on monitoring is also to promote rehabilitation and then to deter any future conduct that got them where they are in the first place. So yes, they made a mistake, they did something wrong, but that's over with now. They've learned, they've made their mistake, and we're going to move on and we're going to help them and promote not doing that again, basically, along with other things. So I'll just go through some of the lists of the order requirements. So we'll enforce the board orders, kind of like what Leslie was saying about different types of stuff. Costs and forfeitures from a liaison standpoint don't really have to deal with too much of that. Costs of the proceeding or forfeitures. Forfeitures usually are from citations from mainly, I get a lot of those from cosmetology board, along with some other things, but costs typically have to be paid anywhere between, I've seen 30 up to 120 days. Education, there's disciplinary, non-disciplinary, and the non-disciplinary that we kind of went through before already is remedial. There's no limitation on their license for remedial education, but they're still required to complete that education within a certain amount of time. Again, usually it's typically between 38 and 120 days. And it's the same thing for a disciplinary education order, which does in fact put a limitation on their license. Typically what we see, what we need the help from the liaisons is the respondent will send the monitoring unit a proposed education and the amount of hours that it's required. So typically we'll forward that to the liaison to have them kind of review the education to make sure it matches up with what's required of the order. Most of the time it's pretty straightforward, especially a lot for, I'd say, like nursing board. It's pretty, there's a lot of like common websites that are used, but I mean, sometimes you need further information. And then if the liaison needs further information, they can obviously ask more questions and then we can seek the answers for them. That's not a problem. When it comes to practice related stuff, whether it's nursing, accounting, etc., these are just a few of the different things. A professional mentor, I see this commonly with real estate and along with APNPs. The mentor is just there to kind of oversee their work and make sure that things are going well and there are no like issues or anything like that. Some of the practice related job restrictions can be work reporting is commonly, we have forms for those. They report to us quarterly, and along with job approval. So basically what we'll do there is gather information of the job, whether it be through a job description, and then we'll forward everything to the liaison so that they can kind of make a determination on if the job will meet expectations of the order and if it'll be a good fit. So some of the things that kind of go with monitoring, this has to do with like there are mental health aspects, or there are also assessments in regards to AODA. So they'll require like fitness to practice evaluations, and AODA assessments are obviously the major and the most common ones. And what happens here is that they again have a timeline anywhere between like 30 and 120 days to complete the assessments. And then we'll forward those on to the liaison for review. If the liaison sees fit that no further stipulations need to be added or anything like that, they can make that decision. I'd say most of the time they like to forward it to the board for discussion and consideration, which is obviously their choice and the most common way we usually go. When it comes to impairment orders, this is our drug and alcohol testing. So we use our third-party drug and alcohol monitoring is through Vault. It's a national company. They do very well. Everything is set up through them, and then we're in constant communication with Vault and as well as the respondent. So drug and alcohol testing typically on a 5-year impairment order starts at 49 times a year that they need to drug and alcohol test. And then those panels and everything are set up, and it kind of coincides with the reason that they're put on the order in the first place. I'd say a lot of the impairment orders usually have to do with some sort of diversion or alcohol related type stuff. So when we're drug and alcohol testing them, that many times, it's kind of geared for what exactly they were put on the order for in the first place. Along with that, AA and A meetings are required. We usually are, most of the time the orders require that they have to attend AA and A meetings twice a week. Online AA and A meetings as of right now are allowed, and it's kind of been the way ever since the pandemic that things have been going. So they're also required to seek AODA counseling. Most of the time in the order, there's not really a set amount of AODA counseling that they have to do. It's usually per the treater and how they want to go about it. And again, practice restrictions. Like I said before, usually it requires pre-approval. Commonly with, I'd say, nurses, if it's a diversion case, they're not allowed access to controlled substances. And there are some other intricate things, but that kind of go with that. So when it comes to the monitoring liaison, they're usually given authority to make like the decisions that we request of them per the order. But otherwise, we have the delegated authority, which all boards review and look at the beginning of the year and ratify it. So if an order doesn't specifically say that the board designee has authority over something, the delegated authority gives the liaison the authority to make the decisions and anything that we're asking for. And like I said before, if there's anything that a liaison is not comfortable with and they don't want to make a decision, it's perfectly fine to put it towards the board to make those decisions. However, when it comes to stuff like work and treatment and getting a treater approved, we kind of ask that they make those decisions because I think it's kind of for obvious reasons. When it comes to work, if they have to wait a month or 2 months before they can go in front of a board to ask if a job can be approved, more likely than not, that job's not going to be waiting there for them after that. So like I said too, if you need more information, please don't be afraid to ask us. That's not a problem. We'll do whatever it takes and get everything that you need in order to make those decisions. So All right, so now I'll move on to the professional assistance procedure. Mind you, this is pretty much the same thing as monitoring in general. There's not much different. Some of the requirements of this program, there may be some more detailed, like with AODA and AANA meetings and how much they have to attend. But overall, when it comes to monitoring, it's pretty much all the same thing. We're not asking them to do really any more or any less than anybody who's on regular monitoring. So anyways, a little overview of the program. It's a self-report, non-disciplinary, confidential program, and it's available to any credentialed individual through the state of Wisconsin. The program's intent is to protect the public from credential holders who are impaired by reason of abuse of alcohol or other drugs, and it promotes early identification of the chemical dependency. The PAP agreement is for 5 years, and like I said, pretty much the same as monitoring, includes AODA therapy, drug monitoring, and AANA meetings as part of the agreement. PAP is actually regulated by SPS 7, and that's actually available through the Department of Safety and Professional Services website, if that's something that you're looking to review. So these are just a couple definitions. I won't dive into it too much. I think we all kind of know. I guess the main thing is that the board liaison, the PAP board liaison is designated by each board usually at the beginning of the year. So I think everybody kind of knows who they are. So all right, so how do they apply for it? They can self-report, which is kind of the main crux of the program, is that they identify, they realize they have an issue, and before they get into any sort of issues with at work or what have you, they apply for the program, and that's kind of the way they go. So another type is an employer referral. A condition of someone's employment may rest on them joining the program. So they'll join due to that, and will work in conjunction with their employer. There's also a department referral where our attorneys can refer them to the program. Also, when it comes to self-reporting, if it's not, not necessarily self-reporting, but if somebody is in a disciplinary process, another way that they can get referred is usually by their counsel that they retain due to it. So a little bit about the application process. They have to fill out the application and it gets sent to me. So they basically need 3 things. They need the application. They have to have an AODA assessment done within the last 6 months that shows their specific diagnosis, and a statement of fact that the reason basically that brought them to the program. What happens after that is I'll take the time and review, everything, all the materials that they sent me. If there's a case open and they're applying to PAP, typically I'll look at their statement of facts and what they have told me and kind of compare it to the case file and the case notes and the complaint, just to make sure that everything that the respondent is telling me is factual, or if there's anything they forgot to add that I might want to ask questions about, or the liaison might want to know. Ultimately, at the end of the day, the PAP liaison is in charge of deciding whether they're allowed entry into the program or not. It's kind of the same circumstance. The more information for the liaison, the better. So, and if the liaison wants more information before they make a decision on allowing them into the program, can obviously ask me, and I have no problem going about getting any and all information you need to make your decision a lot easier and a little more comfortable for you. So, say they're accepted into PAP, I'll draft the PAP contract, And the PAP contract, basically says everything almost a 5-year impairment order that we were kind of talking about before does. One of the things that I'll also ask the liaison when it comes to practice restrictions, obviously practice restrictions for somebody who is a nurse and somebody who is an accountant are not obviously the same thing. So I really count on the board liaisons on their specific boards to kind of narrow down those practice restrictions. So once I draft the agreement, I send it to the credential holder. It has to be signed by them and they have to return it within 15 days to me. And then once it's signed by them, I sign on behalf of the liaison and I also sign. And then the date that the respondent signs is the date the agreement starts. So just to go through some of these restrictions real quick when it comes to monitoring them. AODA therapy, which we kind of touched on with monitoring. Monitoring, it's usually per the treater. However, when we're in PAP, we advise they have to have at least 2 sessions per month with AODA therapy. That's at least for the first year. AANA meetings are twice a week. And like I said, they can do those online. Drug and alcohol monitoring, PAP is a little different and starts at 48 screens. Additional tests can be added on or not. So, and just to touch on that a little bit more, when we start at those, so PAP starts at 48. I know in monitoring it starts at 49, but there's a progression each year they can have. They can do modify their order. So the drug and alcohol monitoring is typically the one that they seek the most because it's the most expensive. So the less tests they can do is more money in their pocket. So there's a progression. So we start at 49 or 48 for PAP. The next step down is 36 tests per year, and then 28 tests per year. That includes a hair test. And then ultimately the very least they can go in testing is 14 a year. Plus a hair test. So drug and alcohol testing, whether it be for monitoring or for PAP, never goes away. It's there for the length of the order. So they're required to do quarterly reporting. So they'll send self-reports. They have their AANA logs, and then of course there'll be supervisor reports along with treatment reports. All those are forms that are available on our website. I also send them to the respondents so they have them when they, and then with their due dates. So this just talks a little bit about the practice limitations, direct supervision. Like as I was saying, no access to controlled substances. Obviously that's if applicable, depending on what the board is. When we talk about direct supervision as it relates to the medical field or the nursing field, they can have up to 3 pre-approved supervisors, and those supervisors have to have a credential in good standing. They can't be on an order or anything like that. So, and they're with that, obviously they're not supposed to be using any drugs, but alcohol is also something that is restricted as well. And then just this slide just kind of talks about the types of modifications that they can do on an annual basis. So like I was talking about just briefly a moment ago, reduction in drug and alcohol screens are the most popular, obviously, because, 48 times testing per year can get rather expensive. And then reduction AODA or AANA meetings, also maybe lifting some practice limitations, such as maybe if someone is not allowed access to controlled substances, maybe allowing them access to. PAP obviously works the same way as monitoring or promoting rehabilitation. So after a year or two or a couple, eventually things start getting easier. The usual thing I kind of say to respondents is that once you get to the 3rd year, the first couple of years can be a little bit difficult in finding a routine and everything, but once you get to the third year and you kind of make it through and get into the fourth and fifth year, you're still reporting, we're still monitoring you, but once year 4 and 5, you're kind of basically, for lack of a better term, on your own, and then just proving that you're able to get back into the workforce without being monitored at all. So a little bit more about Vault. With Vault, they're required to check in every day of the week, regardless if it's a weekend or a holiday. If they're selected to test, they have to go to a testing site within 5 hours of notification and to provide the sample. The credential holder is allowed to travel. However, if they're traveling, they have to keep in mind that they're still required to check in and they're still required to test. As I was saying, Vault's a national program, so if they contact Vault, at least a minimum of 2 weeks in advance is what they require. They shouldn't really have a problem finding a testing facility or even getting one approved that's in the area. However, Vault does not have anything outside of the 50 United States. So if they decide to travel international, I mean, they can, but they're not going to be compliant with their contract. So because they'll be able to check in, but if they're selected to test, they're not going to be able to test outside of the country. So, and just some expectations of the program. Usually it's just routine contact with me. I do usually communicate, I think, on the PAP caseload is usually the people I talk to the most. Obviously, PAP is not a treatment facility or provider. It's a program designed to give a participant an opportunity to seek the help and maintain their professional license. The participant always has the option to retain legal counsel anytime. That's not forbidden. And I'll aid in communicating with the employers and with any specifics as regards to their contract and what they can and can't do when they're at work. These are just some frequently asked questions. Next slide, sorry. PAP is 5 years. It's non-negotiable. If they leave early, they'll end up being referred for investigation, where they'll face most likely further discipline, possibly like a public 5-year order. Can they be enrolled in another state's program and still be considered in compliance? Yes. I actually have I have a few individuals, one who's out of state and some who are in state, where either that state is communicating with me regarding their compliance, or I'm communicating with them on a quarterly basis, or sooner if need be, if there's any sort of non-compliance. When it comes to testing, this one's a big one, working 12-hour shifts. Unfortunately, they have to find a way to make it work. If they get selected to test at work, hopefully, I'd say most of the time the employers already knows about it and they're willing to work with them, so they'll let them leave and go test. Some of the places that a lot of respondents work at, they're a Vault approved testing site, so they don't even need to leave. They can just go and do their testing there. But either way, unfortunately, they have to make it work. So can you find employment with practice limitations? Yes, I know with this and monitoring, a lot of people think it's, I guess for lack of a better term, that it's the end of the world, that they're not gonna be able to find a job. They can and they will. There are plenty of employers out there who are willing to give anybody a chance and a shot. So, and the cost for participation, the department itself doesn't cost, or we don't charge anything. However, when it comes to AODA therapy, drug testing, stuff like that, that's all out-of-pocket expenses that they have to pay to those separate entities. So And as well, a credential holder cannot communicate directly with the liaison, they communicate through me. However, usually that's kind of done by them writing letters and, I'll pass it off to them. And if somebody's denied from PAP, they have 10 days from the date of denial to appeal it, and then that can be taken to the board for further consideration.
We had a question from Don Brost from the Radiology Examining Board. His question is, can a credential holder that is being monitored request a break in testing to travel? If so, how are the missed tests handled?
So there are some boards out there that do allow that, and I believe, was it radiography?
Yes.
That board, radiography is one that does allow the board or the board's liaison to allow a break in testing. Obviously, it's at the discretion of the liaison. So what would happen is we'd have the credential holder explain their situation in the form of a letter, and then send it to the appropriate liaison, whether it be monitoring or PAP, and let them make the final decision.
Okay, the next question is for Leslie. It's from Krista Wilson from the Pharmacy Examining Board. I get confused with the term stay of suspension. My understanding is that a suspended license is allowed to practice again. Can you confirm my understanding of that or elaborate if there's more to it?
Thank you, Krista, for the question. A stay of suspension means that the suspension has been imposed and is in place. However, temporarily not in effect, but the person is still under the terms of it. For example, someone's given a 6-month suspension that is stayed, but they must adhere to certain terms, such as not commit any further misconduct, make certain reports, or other types of conditions. At any point during that term of stay, if there's a violation or the board finds that the stay needs to be put back into place, the suspension is already there to implement. It's different from not having a suspension and then having to initiate one.
Thank you, Leslie. We have 2 more questions, but they will apply to the whole presentation generally, so I'll take those while
Thank you.
I excuse our presenters. Thank you very much.
Thank you.
So we had a question come from Todd McEldowney from the Physical Examining Board. His question was response to the presentation on our screening panel, but it has effects throughout all of our board business. His question was regarding whether there is an obligation for a screening panel member to preserve information received, including personal notes. So as a point to remember, materials that are provided by the department, if they're uploaded to our SharePoint site and you as a board member print those materials, you can discard them after you are done utilizing them, because the department will remain the custodian for those materials. If you take personal notes regarding any cases or any board business, those are not public records, but they should also be destroyed when you're finished with them. And then the last question we received is from James Gersick of the architect section. And his question was regarding confidentiality duty and how far that extends. Does it extend into perpetuity? So for board members and case advisors, confidentiality is important, and to preserve the integrity of the final result, to assist our investigation process so individuals remain cooperative with the investigation, and to uphold the board's actions as an impartial decision maker. So when a case is closed, the materials themselves may be subject to open records, but board members and case advisors should always refrain from commenting on individual cases. And I want to thank all the presenters today for their time, but I also want to thank you as board members for joining us today and for your time and for your service to the people of Wisconsin. So thank you again and have a nice day.